Today is a session on consumer and debt, 3 hours of everything you ever wanted to know about debt. Alison, for those of you who are return attendees, you will know Alison has done this session several times. It's also part of the introductory training for new advocates. So it will be useful for all of you. I think by this time in the conference, all of you know who Alison is. So I will just hand it over to her. Oh, sorry, just to say, we'll have questions, I guess, in the chat, and then I'll let Alison know what's come up.
Great, thanks, Lois. So, as Lois said, my name's Alison Ward. I'm a lawyer with the Community Legal Assistance Society in class. I run a Law Foundation program, a Law Foundation funded program called the Community Advocates Support Line, where I work with many of you around the province on poverty law issues that you encounter in your work. My pronouns are she and her, and I am in East Van today, coming from the traditional unceded territories of the Coast Salish peoples, including the Musqueam, Squamish, and Tsleil-Waututh. So I have a PowerPoint for you today, and I'm just going to get mine started here. The PowerPoint is available on SCED. I think Kayla's uploaded it this morning, so you will see it there. And I apologize that I didn't notice until the weekend that the title in SCED is actually Debt and Consumer Law. It should have just been Debt Law, because we only have, well, we have 3 hours, which seems like a lot of time. But it's a very ambitious idea that we can talk even about some basics of debt law in a 3-hour period, much less to do with consumer law. So I'm going to run through a bit of an introduction to debt law and just talk about sort of what debt law is, because in fact, debt is not a particular area of law. And so talking about any issues related to debt is very complex, because many pieces of legislation interact and affect legal issues. So it's important for everybody to be aware of sort of the various different types of debt law. So what I've got is a few slides that attempt to kind of sort of highlight common issues in debt and kind of categorize them and give a few resources. But first I want to talk about what it is that we're going to be talking about today. And so today, primarily, we're going to be talking about debts that are owed to unsecured creditors. That's because there's special rules that apply to secured creditors. So secured credit refers to credit that is attached against collateral, where the creditor has the right, if you don't pay the money you owe, to take the thing that's secured. So examples of secured creditors are mortgages held by banks, where foreclosure can happen against the title to the house, car loans secured against a car. Really, those are beyond the scope of this workshop. There's also special rules that apply to alleged overpayments of government benefits. We'll be talking a little bit about some protection that government benefits enjoy in terms of execution of judgments, but details about, oh, you know, Service Canada says I have an EI overpayment. Do I actually owe it? That is beyond scope of this workshop, because all of those questions become are determined by the specific area of law. So EI law will determine whether or not somebody owes an overpayment, for example, for EI. It's also important to note that there are some creditors that have superpowers when it comes to collection. And so today we're going to be mostly talking about unsecured creditors, like credit card companies are probably a prime example. So what I call super creditors have powers much beyond those of unsecured creditors. So collection superpowers sit primarily with the government, both the provincial and federal government. and with the Family Maintenance Enforcement Program, both of which have the ability to use collection remedies that unsecured creditors, even if they have a judgment, are not able to use. So for example, government and FMEP have the ability to issue attachments to scoop a bank account without first needing to have a court order authorizing to do that. And they can also attach certain kinds of benefits like EI and CPP that other creditors cannot. So when it comes to FMEP attachment, any debt questions to do with FMEP really are answered in the legislation that applies to FMEP, the Family Maintenance Enforcement Act and Regulation. And I think there is or was a session in the conference this year specifically related to FMEP.
Yeah, there was. I was just going to say that. It'll be posted later.
Okay. So if that interests you particularly, then really recommend that you look for that workshop when it's posted later. Next slide, please. So in terms of how debt issues show up in your work, I think it's useful to think about different ways that clients might present with debt issues. Because often clients come in and they may not be very specific about what's going on, and they may not know, for example, why money was taken for their bank account, or they're worried about how things might be collected, or they don't know at what stage of a process they're at. So I'm going to just give a quick overview of some ways debt issues can kind of walk in your door. And again, noting that each of these engages different laws and rules. And so we're going to need to be very specific when we're talking about debt issues. So probably the most common issue that you might see is clients being very stressed out because they're receiving letters from a creditor or calls from a collection agent, and it's causing them a lot of stress, and they want to know, what can happen? Can the debt collector seize my car? Can I get them to stop calling? It's causing me so much stress. So one thing we'll be looking at in the workshop today is regulation of collection agents, which is done by Consumer Protection BC under the Business Practices and Consumer Protection Act. And we'll look at some remedies that folks have with respect to communication with debt collectors. Of course, you'll also see clients that are unable to make full payments on all of their bills, but may have some ability to pay. So, fundamentally, most debt problems are financial issues. And sometimes the problem is simply that the person is not able to pay all of their bills as they come due. But if their debts were restructured in some way, they might be able to make smaller payments to all of them. So there are resources for clients for whom financial remedies to debts might be helpful. And I always refer to the Credit Counseling Society. There are many debt repayment companies out there, but in BC, the Credit Counseling Society is the only nonprofit one that exists. I've got their website up there. And so services from the Credit Counseling Society include debt consolidation, debt management plan, so that can mean that the Credit Counseling Society can negotiate with a creditor to have an interest rate reduced, to have reduced monthly payments that actually fit a person's budget. There's a whole array of services that they can provide. And they also provide financial education so that hopefully, folks can become more adept at managing their financial affairs. So the Credit Counseling Society, because of course, I'm talking about clients who have some ability to pay debts, and that is not always the case. Of course, there are clients who are overwhelmed by their debt load and may not be able to, even with reduced interest or reduced payments, manage their finances. And so in that case, the Credit Counseling Society can give folks some information about bankruptcy, but only a licensed trustee in bankruptcy can actually help someone declare bankruptcy. So if you have a client that is interested in declaring bankruptcy, bankruptcy really is a remedy of last resort. And one of the criteria that someone has to meet to declare bankruptcy is to show that they're not able to make a viable proposal to their creditors to meet their debts in some other way. And so if you have a client that's interested in bankruptcy, it's still a good idea to refer them to the Credit Counseling Society, because the Credit Counseling Society can help them figure out, oh, are you able to make a proposal to your creditors that would meet your debts in some other way? If the Credit Counseling Society doesn't think that they can, well, then bankruptcy might be a good idea for that client. And they will need to meet with a licensed trustee in bankruptcy to discuss the issue with the trustee and see if the trustee agrees that they're eligible to declare bankruptcy. So trustees in bankruptcy are licensed and regulated under the Bankruptcy and Insolvency Act by the Federal Office of the Superintendent in Bankruptcy. I've got their website up there because they do have quite a lot of information about bankruptcy laws, the procedure that is followed when somebody declares bankruptcy, and information, for example, about debts that are and are not forgiven in the bankruptcy procedure. Next slide, please. Other client situations that can arise, clients may have received court documents because a creditor is suing them on an alleged debt. And of course, they may be wanting your assistance in responding to that. My advice there is that you need to refer them to a lawyer for legal advice and for help responding to the court documents. The lawyer would look at issues like, does the client have a defense to the debt? For example, has a limitation period passed, or is there some other defense that can arise? As I said earlier, clients may also have questions about alleged overpayments of government benefits. And again, government benefit overpayment questions are dealt with under the relevant area of law. So for a welfare overpayment, the question of whether they owe it is a question of welfare law. And also, in some situations, it may be possible to apply to have government benefit debts written off under the applicable law. So for example, that is something that's available for EI overpayments. So for the poverty law advocates in the room, those are issues you'll be dealing with yourselves. For folks who aren't poverty law advocates in the room, you can refer those issues over to the poverty law advocate in your community. There are other debt-related issues, issues related to debt and bankruptcy that may arise too. Bankruptcy is a procedure that happens in BC Supreme Court. And you may encounter clients who have already filed for bankruptcy and who, for whatever reason, weren't discharged from bankruptcy, or their discharge from bankruptcy was refused, meaning they're kind of held in limbo in bankruptcy, and they may want to ask you what they need to do. I've posted a link to a really great resource that exists. It's published by the BC Supreme Court, and it's a guidebook for discharge from bankruptcy. So for folks that are needing to pursue their own discharge from bankruptcy because maybe the court refused their discharge before for some reason, the trustee may also have been discharged and is no longer available to help them. So that's a very useful resource to be aware of. Next slide, please. Of course, you also have many clients that may come to see you about student loans. Many students, former students, have difficulty paying their loans back and wonder what rights they might have in relation to debt management or debt forgiveness. Student loans fall under specific legislation. Federally, there's the Canada Student Financial Assistance Act. And then in BC, we only have a provincial student loan policy. We don't have a specific student loan statute. But of course, all provinces and territories issue student loans as well. And you may be seeing clients that have student loans from other jurisdictions, like an Ontario student loan, for example. I will say that student loan issues are quite complicated. There's a lot of information to be aware of. And I was just talking to Lois as we started the session, saying that as I was preparing the workshop today, I realized I don't have time really to do any justice to student loan topics, and that it may be a very good idea to have a separate workshop down the road outside the conference to do with student loans, and I think maybe student loans and bankruptcy as well. And Lois said, sure, we've got SCED. We could arrange something like that. So if that is something that appeals to you, maybe just make a quick comment in the chat so that
it does.
Yeah.
They're already getting comments in the chat. Yes, there you go. Lots of people. Well, not lots of people, but just backing up a bit, can I just flag for you that there was a question about whether bankruptcy discharges debts on reserve. You can hold that for later or do it now.
Yeah, there's a section in the Bankruptcy and Insolvency Act. I think it's difficult to say whether any specific debt would be discharged in bankruptcy without knowing what the debt was for. So let's hold that question. All right, so in terms of student loans, I think that hopefully we'll have a workshop down the road, a special workshop down the road. But for certain people in the room, you may just be in a different, maybe you're not a poverty law advocate, you do more general information, or you're a family law advocate looking for sort of the basics of things. It's important to know that under the student loans legislation, student loans can be forgiven based on severe and permanent disability. There's very specific criteria that have to be met, and there's quite a lot of information available online. So I've put the link to the eligibility criteria and the application forms for student loan forgiveness based on severe and permanent disability there as well. So in terms of other issues that might come in your door, you may see quite a number of consumer law questions. Somebody wanting to know, are they able to cancel a contract? Maybe they're having regrets, or they're not knowing if it was a good idea to have entered into a particular contract that they did, and they want to know if they have cancellation or other rights. They're the place to start is with Consumer Protection BC. Which administers the BC, Business Practices and Consumer Protection Act. They license certain sectors in the economy. For example, they license and regulate debt collectors, some travel industries, funeral homes, a whole kind of array of areas, and they regulate some types of consumer contracts. So for example, they regulate payday loans and kind of categories of contracts. So those categories include distance sales contracts, which implies, purchases that happen at a distance. So for example, online shopping. They also regulate future performance contracts. Those are contracts where a down payment has been made, but full payment isn't due until later. So for example, if you're doing, a repair or renovation on your house and you make a down payment when work starts and the balance is due later, that might be a future performance contract that's regulated by consumer protection. Another example of contracts I regulate are called continuing services contracts. That's contracts for services that are ongoing and that are physical in nature. So that includes gym memberships, personal training, weight loss services, for example. So for some of these types of contracts, there are cooling off periods, which is a term kind of used to the idea that, oh, there's a time after you've signed the contract to cool off and change your mind and cancel. And there's often also very specific requirements about what needs to be included in each type of contract. So like disclosure of the cost of credit, fees, and so on. And if the specific information that's required isn't included in the type of contract, then quite often the person is given the right to cancel the contract for a period of time after they receive the proper information. So if the proper information isn't included at the outset, they may have the idea maybe that they have 10 days to cancel from the date that they receive all of the information that they're entitled to in the contract. Consumer protection also regulates gift cards as a, and also regulates direct sales contracts like door-to-door sales, for example. So it's important to know that where there has been a violation of one of the rules that's contained in the BPCPA, the Business Practices and Consumer Protection Act, consumer protection takes complaints, and where there's been a violation of one of the rules, you can file a complaint, and consumer protection can do two things. They can work with the person, and if there is a violation of one of the rules, they can work with the person and the company to ensure that the act is followed. So for example, that the person is allowed to cancel their contract. And for industries that they regulate and license, they can also, in some cases, take action against the license of the, say, for example, debt collector or other service provider that they license. So I've included a link to their website there. They have a lot of information up there, sort of categorized by type of contract, so it's quite useful to take a look. And they also offer information and referral. So I think that they get a lot of inquiries from people that actually don't have a problem that falls under the areas that they regulate, but they do have some other information up on their website saying, oh, you have an issue with a car dealer, for example, that doesn't fall under our area of protection, but there is somewhere else that you can go to complain about that kind of issue. So they're an important resource. Next slide, please. And so the last types of client situations you may encounter that I wanted to go over are things that we're going to be talking about in more detail today. So clients may wonder, I have this old debt that's been hanging over my head forever. Well, does the debt ever die? Are there deadlines for collection of debts? If so, what are they? Or the client may already have a judgment that's been entered against them by a creditor, and they might be very worried about what a creditor might do. So they want to know what steps can a judgment creditor take to enforce the debt, and what limits are there. Or they might be in crisis because something has already happened. Somebody has a judgment against them, and the creditor has taken enforcement steps against them. So for example, they've had their wages garnished, or CPP or other benefits taken out of their bank account, and may be in crisis because they need that money to live on this month. They can't pay their rent, they can't pay with their groceries, and they want to know if there's anything they can do to try and remedy the situation in the short term. So as you can see, there's many different areas of law that intersect in debt law and many different types of questions. And so because of that, it's also important that you as advocates have good knowledge of what resources are out there to help you. Next slide, please. So we've got, I wanted to give you an overview of the resources that are available to assist with debt law issues. The first I've listed is It's a People's Law School Quick Law Wiki book on consumer and debt law. There are advocates in the room who have been around for quite a number of years. And so you may remember this publication. It originally existed as a legal aid publication. It was a binder that you may remember, some of you, called Consumer and Debt Law. I've certainly distributed hard copies of that legal aid publication in person at conference in the past. Legal aid doesn't manage that publication anymore. It's been taken over by People's Law School, and now it's turned into a wiki book, which is very handy because you, right at that link there that I posted, can access the entire booklet. So I've got a copy of it here in hard copy too. It's available, but not for free anymore. You have to actually purchase it. I have a copy because I was the legal editor of this edition for People's Law School. And so you can take a look at it. You can download it as a PDF at that link. It is about 250 pages in all. It's specifically designed for advocates and community workers. So if you take a look through it, you'll see that there are about 45 different topics, including some of the ones that we've just included in the overview. So if you have clients coming to you for debt-related issues or consumer law, this is a very good place for you to start looking. Another good resource is the UBC Law Students Legal Advice Program, or LSAP for short, has a manual that's available online. The manual itself has 22 chapters. It's written for law students at UBC who assist clients in legal clinics around Metro Vancouver. And 2 of the chapters might be helpful here. So there's one on consumer protection and another chapter called Creditors' Remedies and Debtors' Assistance. So that's another place for you to bookmark. And finally, I wanted to highlight that PovNet has a debt law list. So I think most of you are probably signed up for one type of PovNet list or another. If you're already on the housing and welfare list, maybe make sure that you go in and tick a box that will also subscribe you to the debt list. The membership of the debt list is different than the other lists. So for example, it includes representatives of the Credit Counseling Society who may weigh in on questions that you pose. If there are folks in the room who aren't a member of a PovNet list yet, I've included the link there for where you can apply to become a member of the PovNet listserv. So those are closed listservs that advocates and community workers use to ask questions of each other and kind of brainstorm ideas about cases they may be working on and share information. So you can subscribe or apply to join at that link there. Or if you have questions or have trouble signing up, you can email the executive director of PovNet, who is called Nikki, and I've got her email there as well. Next slide, please. Okay, so in terms of a quick outline of the issues that we're going to be looking at in more detail today, we're going to be spending some time talking about the Business Practices and Consumer Protection Act as it applies to debt collectors. How can you deal with debt collectors that are contacting your client? We're going to be taking some time to look at limitation periods. What are the limitation periods that apply to unsecured debts? And what does that mean in terms of steps you might be able to take on behalf of your client? And then finally, some time looking at how unsecured debts can and can't be collected. So there are rules that establish rights for creditors and also remedies for debtors and collection agents, in collection issues. So we'll be taking a look at some small claims, remedies, such as payment hearings, garnishing orders, looking at what assets may be exempt from seizure when somebody has a judgment against a client, and special rules that apply to government benefits that have statutory protection against seizure and collection. maybe this is a good time to see if there's any questions in the chat.
No questions, just a lot of people want a student loan workshop.
Yeah, okay. All right.
Alison, at some point, do you want to have a break?
Yeah, I was just going to say we'll take a break. I was thinking at about maybe 10:30.
Sure.
We'll see where we get to by then and whether that's a good time or not. And I will also say I've got some fact patterns built into the materials as we go on, because I know that it's tough just sitting there listening to me drone on, but hopefully we'll get to some more interactive sections soon. I just want to review some information. So what will the model that we'll use is sort of reviewing information, apply what we talked about to an actual situation. So first, we're going to look at debt collectors and what rights folks have in terms of dealing with debt collectors under the BPCPA. So as I said, the BPCPA licenses and regulates debt collectors. Consumer Protection has lots of information on their website about their licensing role. It's important to note who is and isn't considered to be a debt collector. It's a defined term. So the rules in the BPCPA don't apply to in-house collections. So if you have a company that's owed money and they use their accounting department, let's say, to call the person up and ask them to pay their debt, that's considered in-house collections, and the rules in the BPCPA don't apply to that situation. The rules also don't apply to lawyers acting for creditors. So your client might get a harshly worded letter from a lawyer asking them to pay their client money. The BPCPA rules don't apply to the lawyer, and the rules also don't apply to government collectors such as Revenue Services BC. So what are the rules that do apply when the BPCPA governs a situation? So the collector must provide written notice of the original and current amount of the debt before they're able to contact the client in relation to the debt. And they need to do that 5 days before calling the person. So the client should be receiving a letter. It should have the original amount of the debt, the current amount of the debt, including a breakdown of the current amount owing, the identity of the original creditor and the current creditor. So sometimes, for example, debt collectors may purchase a debt from a creditor, and the current creditor may actually be the debt collection agency that is calling the person or writing to the person. And they also need to show the authority of the collector to collect. Those rules come from section 115 of the BPCPA, and those rules are more strict than they used to be. They changed in, I think it was about 2016. So for folks that have been working in this area for a long time, notice that the rules are more stringent than they used to be, and that I think that a lot of debt collectors, when they write, are not able to provide all of the information that's required by section 115, which of course would be a breach of the act in the first place. And if they can't provide the information required by section 115, I would say that they actually shouldn't be proceeding to call the client to try and collect that debt at all. So there is that disclosure right. So before sending that letter, a debt collector is allowed to phone a client only for the purposes of trying to find out their address or their email address so that they know where to send that section 115 notice. In terms of general constraints on debt collectors, the BPCPA also provides that a collector cannot harass a debtor, their friends, their family, acquaintances, or their employer. And we'll be talking more about, well, what constitutes harassment? But just in general terms, it is possible for somebody who's been contacted by a debt collector and feels that the debt collector has been really out of line, to sue the debt collector in civil court, so in small claims court, for up to $35,000 is the jurisdictional limit of small claims court. So it is possible to sue a debt collector for harassment if they overstep the rules that they need to abide by under the BPCPA. So there are limits on how debt collectors can communicate. We'll look at those in more detail. They cannot contact the client generally at work, with some exceptions. And if the debtor requests, they must communicate only in writing or via the person's lawyer. If that's what the person requests and they have a lawyer helping them with the situation, we'll take a look at that in more detail too. And if a debtor writes to the debt collector and copies it to the creditor, saying that they dispute the debt, that actually stops the debt collector in their tracks legally, and the debt collector in that situation can't further communicate with the debtor at all. So those rules arise from Section 114 of the BPCPA, and we'll be looking at those rules in more detail in a moment. Next slide, please. So the Act sets out quite specific constraints on what debt collectors can and can't do in terms of communication with clients. And this is a chart that I copied from the consumer protection site, setting out sort of in a concise way what those specific rules are. So for example, they can call you on Sunday between 1 and 5, but on other days of the week, they can call you from 7 in the morning till 9, but they cannot call you after 9 p.m. or before 7 in the morning. They're not allowed to contact members of your family or other people other than you, except to try and get your address, phone number, email, contact information. I've certainly spoken with a number of clients who complain that, debt collectors have called other family members or people they work with to discuss details of the actual debt or the personal situation of the debtor or the alleged debtor, and debt collectors cannot do that. So there's other more general constraints. So they're not allowed to use threatening, profane, or intimidating language, to exert undue, excessive, or unreasonable pressure to collect a debt, or threaten to publish a failure to pay except to a credit reporting agency. So I think good advice for people that are dealing with debt collectors is always to keep a little logbook of dates and times that they receive a call from a collection agency and the gist of what was said in that conversation. That's going to be very useful if the person decides that they want to make a complaint about the debt collector to Consumer Protection BC. As they keep their logbook, it's also going to be very useful if down the road they ultimately decide that they're interested in suing the collection agency for harassment. So it doesn't have to be anything complicated, but just a little logbook taking a note of the date and the time, the name of the call, the name of the person calling if they give it, and the gist of what was said. So what happens if a debt collector breaches some of these rules? So as I said, it's possible to make a written complaint to Consumer Protection BC. That kind of complaint can lead to action against debt collector's license. It's also possible to sue for harassment, or short of suing for harassment, there might be some way of trying to negotiate some kind of financial settlement for alleged harassment by a debt collector. I've included a link there to a BC Supreme Court case called Roach and Total Credit Recovery. So that was a case where somebody was contacted I think 3 or 4 times at work by a collection agency. There were some breaches of the BPCPA, and they sued the collection agency. It's interesting because the person was successful and they did receive, I think it was a couple of $1,000s in damages ultimately. But if you read the facts of the case, they weren't that, it wasn't the most egregious example that you could think of. It was somebody that was very offended by the debt collector's actions and decided to do something about it, which has resulted in a very useful case on this issue. But I think there are certainly many more people that probably have good cases against debt collectors. And so it's interesting to read the decision and see what sorts of facts supported the judgment there. In the course of deciding that case, the court found that yes, there is a tort of statutory harassment under the BPCPA, meaning that if the standards set out in the BPCPA are violated, then that can constitute a cause of action and the collection agency can be sued under the statute. In very serious cases where debt collection has harassed somebody or really taken egregious action against them, it's also possible to ask Crown Counsel to prosecute. I'm not aware of any cases where that has happened, where a prosecution has actually been upheld or pursued. But under criminal law, it's certainly true, that a collector mustn't threaten to harm a debtor or their property. You do occasionally hear clients saying things like that have happened. The collector can't abuse its authority to get money from a debtor or convey false information with the intention of alarming the letter. Occasionally, I've seen letters, for example, from debt collectors that are designed to look like a court document, where the person might think that somebody actually has a judgment against them already, when in fact no court cases has even been started yet. So there are misleading documents out there, and theoretically that could lead to requests for prosecution. So I want to look at some of the more specific rights that a client has to constrain communication by debt collectors. So I've copied section 116 sub 4 of the Business Practices and Consumer Protection Act here, because I think it's a very fruitful area where advocates can actually be very helpful to clients in trying to take some steps, not only to stop communication from a debtor, but also to in some cases, dispute liability for a debt and convey information to a creditor that they think it's important for the creditor to know. So let's just look the section over. So subsection A says that, if a debtor doesn't want the collector to phone them anymore, they have the right to request that all communication be in writing. And that must be done if the debtor notifies the collector to communicate in writing only and gives the collector their mailing address. So the Consumer Protection BC has template letters on its site that you can use or refer clients to have them write to collection agents to assert their rights to have written communication only. So that's a very useful template to be aware of. There's also template letters on Consumer Protection site that apply to the other 2 situations in section 116. So let's review those briefly too. The debtor has a right to not have the collector communicate with them except through their lawyer if the debtor notifies the collector of that and provides an address for the lawyer. Frankly, there's very few people with debt collection issues in BC who amongst our clientele will have a lawyer assisting them with it. So that's probably not a very relevant section to the work that you do, but it is there. And finally, what I think is the most important one, or the most interesting one really, is that a debt collection agent must not continue to communicate with the debtor if the debtor has notified the collector and the creditor that the debt is in dispute and that the debtor would like the creditor to take the matter to court. So there is a template letter on consumer protection site that you can use to help a client dispute a debt and send that letter to both the collector and the creditor. And if that is done, then there can be no more communication, and it then puts the ball in the creditor's court to decide, you know, should I take this case to court? Should I start a small claims action? Yes or no? So if you look at the template letter on consumer protection site there, it's quite short. And all it says, I think, is something like, I dispute this debt and want the creditor to take it to court, or something like that. It doesn't have any room for the person to give any information, any more information, like, for example, why they're disputing the debt, or any information about their financial situation. So we'll talk about this a little bit more, but I think that if you are helping somebody dispute the debt and asking the creditor to take it to court, that the template letter on consumer protection site is probably not the best way to do it, because it can be a very good idea to give the creditor more information in that letter. Because if the function of the letter is to put the ball in the creditor's court to decide what to do, to decide, should I take this case to court or not, it's really helpful for that creditor to have, or for the person to give the creditor as much information as possible about the situation as they can. So for example, you all know the expression, you know, you can't get blood from a stone. So if your client doesn't have an ability to pay the debt, and you think, you know, maybe what we call judgment proof, we'll talk a little bit more later about what that means. It's a very good idea to put in that letter disputing the debt that, I dispute my liability for this debt for reasons that we can talk about. And by the way, here's my financial situation. I subsist on Canada Pension Plan disability benefits of X dollars a month. Here's my expenses. They add up to more than my monthly income, just so you know. So as I said, that template letter on the Consumer Protection BC site is too short to use for something like that. So you may want to write a letter that allows for more information to be conveyed. So the other thing that you can do there is put reasons for why the debt is in dispute. And we'll be talking a little bit further about a couple of reasons a person might want to dispute a debt. So we're going to be looking at limitation periods later this morning. So a person does have the right to dispute a debt if they think that the debt is too old, that a limitation period, a deadline for the person to sue them about it has passed. That can be a good reason to dispute liability for a debt. And if that's the case, you may want to put that in a letter under section 116(4)(c) to the creditor and the collector. And as we go along in the presentation today, I think we'll be talking, there'll be more questions, or we can talk more about other reasons why a debt may be disputed. Another thing.
Sorry, there's a question in the chat about someone whose deceased spouse ran up debt, and they're wondering if, and he's getting a lot of phone calls now, so could they use the same provisions to stop that?
Yes, you could use the same provisions to stop that. If it's a debt collector that's licensed under the BPCPA, then these sections would apply. In that situation, there's an issue about whether the person would actually be responsible for their deceased wife's debt. So normally, if I have a spouse and they have a debt and the debt is in their name only, I have no responsibility for their debt. But It might be that it was a joint debt. Maybe they had a credit card that was joint and that they both signed. I don't know. Where somebody has passed away, their estate is responsible for their debts, but the spouse would not be personally responsible for the debt. So if the person has passed away, I wonder who the executor is, if they died with a will, who's the executor of the estate. The collector could be contacting the executor of the estate about the debt issue. But if the spouse isn't the executor, then they shouldn't be contacting the spouse in that way. So again, probably need to clarify the facts a little bit, but yes, this could apply depending on the situation. I was going to say too that one thing to note about section 116.4c is if somebody is disputing a debt and asking that it be taken to court, or at least putting the ball in the creditor's court to decide if they'll sue or not, it's a good idea to make sure that you have a record of doing that, because of course we don't know whether or not the collector will obey, will comply with that line in the sand that's being drawn here around their communication. So it's a good idea to send any of the letters under 116 in a way that you have proof that they've been sent. So that might be sending it by registered mail. That might be sending it by even email, although it's difficult to prove that an email has been received. It could be sending it by fax where you've got a fax receipt, but probably registered mail is the most reliable way of being able to show that you've asserted a right under section 116.4. And so if you assert a right around communication under 116.4 and the debt collector doesn't comply with the requirements of the rule, and in fact continues to call the person despite them saying, I don't want to talk to you, I only want you to write to me, I wrote to you saying that, if the debt collector continues to call, then that is the basis for a complaint to consumer protection. And if you sent the letter asking for written communication only by registered mail and you have proof of that being sent, you file that proof with your complaint to consumer protection, and consumer protection can then look into it and hopefully get the debt collector to stop communicating with the person by phone, and also consider any regulatory action against the collector's license. Okay, next slide, please. But we could try our hand at a fact pattern now. So we have a client named Roxana. She gives you a call this morning. She's totally stressed out. She says she owes about $4,000 on an old credit card debt from about 3 years ago, around the time her son was first born. She moved a lot and she thought the creditor had forgotten all about it, but she's been getting collection calls almost every day for the past 3 weeks asking her to pay. She says she's a single mom and she can't afford to pay anything. She told the debt collector that, and they sent her a budget sheet to fill out. And she hasn't done that yet. And she comes to see you saying, this has happened. I've got this budget sheet here. I'm still getting calls. I don't know what to do. So what would you tell Roxana? So first of all, she says she can't, she's getting collection calls that are stressing her out. She says she can't afford to pay anything. And they've sent her the budget sheet to fill out. The debt is from about 3 years ago. What do we have for comments? Yep. Someone says you can ask the collector to only communicate with Roxana in writing. So she could write a letter to the collection agency asking them to communicate in writing only, which might help relieve her stress. Write to the creditor explaining unable to pay and asking them to communicate in writing only. Yep. Check the statute of limitations for pursuing the debt. That's a great idea. We'll talk a little bit more about limitation periods in a couple of minutes. Someone's asking, is there consumer debt is only 2 years of shelf life? Someone's asking, what is the source of your income? Which is also a great question, because that, we'll talk about that more down the road, but that gets to the question of, oh, you know, can she be collected against in any event? Has she made any payments toward the debt? That's a question that also gets to the limitation date issue that we'll talk about next. So these are all great questions. One thing I want to point out is that this does preface the limitation discussion that we're going to start in the next couple of slides. One of the things that I want to flag here is that they've sent her a budget sheet to fill out. It's very common when somebody tells a debt collector that they're not able to afford to pay the debt that they're calling about, that they send a detailed budget sheet for them to fill out. And so I just want to sort of flag that you need to be careful with that issue. Oftentimes, in the small print of those budget sheets down the bottom, there is a section that basically says, by filling in this budget sheet and signing, I acknowledge that I owe this debt, or something like that. So that's a red flag to look out for. What other comments do we have in the chat here? Has she made any payments towards the debt? Yep. Okay, so I think what we've said is, well, we can tell her that she definitely has the right to write to the debt collector and ask them to communicate in writing only. And we've also got more questions about the situation that look at what else could happen here? Is there a limitation date defense? Could she be collected? Does she have, things that can be collected about? So we're going to look at more information there. So, so as we said, she hasn't made a payment in 3 years. And if it's a case that she hasn't made a payment in 3 years or agreed in writing that she owes it, it may be too late for the creditor to sue her. So has the limitation date passed? What do we need to know to determine that? We need to know, what is the limitation period that applies to credit card debts in BC? When did she last make a payment? Someone had commented that in the chat. And when did she last acknowledge her responsibility for, there's a typo there, for the debt in writing? So as I said, you need to be careful with that budget sheet, because by completing the budget sheet, she might inadvertently acknowledge her responsibility for the debt. And similarly, if you're writing to a creditor on behalf of a debtor about a debt issue, you need to be very careful that you don't acknowledge the person's responsibility for the debt in writing either, because a written acknowledgement by the person or by their agent can restart a limitation period. So it's a good idea whenever you're writing to a creditor or a debt collection agent about somebody's a debt they say the person owes, use language referring to things like the alleged debt. You may even want to start writing to a creditor by saying, I'm writing on behalf of Ms. Shelton with regard to the alleged debt she owes on her CIBC credit card. Please note, Ms. Shelton does not agree that she owes this debt in any way, period. So you want to be very assertive about the fact that, look, we're not acknowledging the debt here. In fact, we're denying the debt, but I'm going to write to you to provide you some information because I may want to let you know about their financial situation, to say they're on welfare, they're on CPPD, they have no assets, and so on. But you always want to make sure you're assertively making sure you're not acknowledging their liability for the debt. Next slide, please. So that brings us to limitation period issues. So limitation periods have to do with time. And so I've got some handy calendars there as our illustration. And we can move into the next slide. So the basics of limitation periods are, first of all, So a limitation period is a deadline to start legal action, either with respect to a debt or an event that occurred. There's limitation periods really for every kind of court case that can be started in BC. All we're going to be talking about here in this workshop is a limitation period that applies to unsecured debts. So most, but not all, limitation periods in BC are governed by the Limitation Act. It's a provincial act. The current version of the act has been in force since 2012. In certain cases of older debts, it's possible the old act applies. As more and more time has gone by since the new act came into force in 2012, I think it's becoming less and less common that we need to look at the old act to see what rules apply. The most important thing to know probably about limitation dates is that missing a limitation date creates a defense to a claim. But calculating a limitation period can be very tricky. Lawyers are very hesitant to give people advice about limitation dates because if you get a limitation date wrong and somebody misses a deadline to sue someone by, then there can be a lot of liability attaches to that. So for limitation periods, it's generally best to give legal information, not legal advice. So it's also important to note that the limitation periods in the Limitation Act only apply or don't apply if there's a more specific enactment that applies to the situation. So for example, if we think about the Residential Tenancy Act, there's a deadline in the Residential Tenancy Act of 2 years generally to apply for a monetary claim against a landlord. Because there's a specific deadline set out in that enactment, the limitation period or the Limitation Act doesn't apply to RTA claims for monetary orders. Instead, we look at the RTA for that deadline. We only look to the Limitation Act if a statute you're dealing with doesn't have a specific deadline in it. Next slide, please. So for unsecured debts, there's a basic 2-year limitation period for debt claims discovered since June 1st, 2013. A really important question is, when does a limitation period start to run? So the rule there is that a limitation period starts to run from the date on which the claim was or ought to have been discovered. So if I have a credit card and I'm keeping my payments up to date, I pay, my bill off every month, there is no claim that my credit card company has against me. But if I miss a payment, then that would start the running of the limitation period for the credit card company to take legal action against me. There's a couple of specific rules to know about. So generally, limitation periods don't run against minors. So if somebody's under 19, the clock of their limitation period doesn't start running against them until they become an adult for most claims. And limitation periods also don't run against people under a legal disability. So that means, person under a legal disability really refers to somebody who is incapable of managing their affairs, or their ability to manage their affairs is substantially impacted. So in that situation, they may have had a committee appointed to represent them as a substitute decision maker, or they may meet the threshold to be declared a person who needs to have a committee appointed for them. So it's quite a high threshold, but if somebody is under a legal disability, a limitation period does not run against them. And then finally, limitation periods are restarted by an acknowledgement. That's a rule in Section 24 of the Limitation Act. So what is an acknowledgement? So an acknowledgement is either a signed written acknowledgement of, in this case, the debt by the person concerned or their agent. And a signed written acknowledgement restarts the limitation period timer. A partial payment on the debt also restarts the limitation period. So that's why we had someone commenting in Roxana's situation. Oh, when did she last make a partial payment on the debt? Because if she made a partial payment last month, even though the debt itself was 3 years old, that would have restarted the limitation, may have restarted the limitation period. As an exception to the general 2-year rule, we know that debts to the BC government carry a 6-year limitation period. That's because there's a section in the Financial Administration Act that specifically says that. And then I've highlighted the last point, which is that acknowledgements and payments made after the limitation period do not restart limitation periods under the Limitation Act. So I just said Roxana's debt was 3 years old, and if she made a payment last month, that may have restarted the limitation period. We don't know, because if there had been a period of 2 years that elapsed already with no written acknowledgement and no payment that she made, then the limitation date has arguably already passed. And if last month she made a payment after that 2 years had run, a payment made after a limitation period has passed does not restart the limitation period in this case under the limitation period, under the Limitation Act, rather. Next slide, please. So there's a separate limitation period that applies to judgments. So if a creditor has already sued somebody and obtained a judgment against them, that judgment can be enforced for a period of 10 years from the date of the judgment. And judgments can also be renewed. So a creditor can renew a judgment for another 10 years. The way they do that is by starting a new lawsuit against the debtor. Basically, they sue them on the judgment that they already have, saying, basically this, I'm suing you because you owe me money. My proof that you owe me money is this judgment here, and I'm starting this new lawsuit. So in order to renew a judgment in that way, the creditor has to start that second lawsuit to renew it before the 10 years elapses. If 10 years go by, 10 years and 3 days go by, and then they file their lawsuit, it's going to be too late, and that person may have a new limitation defense to a renewal of the judgment. Okay, so let's take a look at another fact pattern. If you can have the next slide, please. So here we have Frankie. So Frankie calls us today. They say they've applied for income assistance and that the ministry's told them they need to open a bank account to have their welfare deposited by electronic funds. Frankie says they haven't had a bank account for many years because ICBC obtained a judgment against them for about $100,000 12 years ago. They don't want to open a bank account because they're worried that if they do, ICBC will garnish money from their bank account. So what can we tell Frankie? It's pretty common, I think, to have clients saying, you know, I don't want to open a bank account because I think that if I do, you know, my creditors are going to try and enforce against me. I have some judgments, some old judgments. I'm worried that if I open a bank account, something bad will happen. But here the minister is saying they need to.
You have a few comments there.
So income assistance is protected. We'll talk about, you know, the fact that some government benefits are protected in some ways from enforcement. Yes, somebody says, yes, Andre, ministry cannot require that the funds are paid by direct deposit. And yes, that's a bit of an aside, but that is actually very true. The ministry will generally tell people, their policy is to tell people that direct deposit is a mandatory means of payment of welfare in BC. That is their policy, but then their policy basically goes on to say that, you know, if a client refuses to have direct deposit, we note the reason and they get a check instead. So that's important to know, because there are many clients who that very validly think that they'll be enforced against if they open a bank account. Others may be misinformed, but yes, that's very correct. Ministry cannot require that funds are paid by direct deposit. Somebody is asking, has the judgment been renewed? That's a great question, because we know that the judgment is about 12 years old. So the judgment might have expired because generally they're only valid for 10 years for enforcement, but it might be that they renewed it. So we would need to find out if it was renewed. If we find out that we find out that it wasn't renewed, then there may be a limitation period that has elapsed and ICBC might not be able to enforce it anymore.
And that's the same point from Christy and Sonia. See the final question from Gudrun about whether ICBC?
Yeah, is ICBC able to require all banks to share banking information? I don't think so. I think that that would be a violation of privacy law as far as I know. So I don't think so.
And so I missed one question when you were talking about limitations. There was a question about whether the limitation period of judgments applies to CRT judgments as well.
No. So the Civil Resolution Tribunal does not have the ability to enforce its own judgments. So if somebody wants to enforce a CRT ruling, they need to file it with small claims court for enforcement, in the same way that if a tenant has a monetary order against a landlord from the residential tenancy branch, the RTB they can't force a landlord to pay. So a tenant needs to take a monetary order and file it with small claims court. That has the effect of turning the order into like a small claims court judgment that can then be enforced. Same thing with the Civil Resolution Tribunal. The ruling can be filed with small claims court for enforcement, but that can only be done after there's a period of time in which you can object to a CRT ruling. So the period of time for objecting to it has to be over, and then it can be filed with small claims court for enforcement, just like a small claims judgment. And then that judgment would be valid for 10 years once it's filed with small claims court. Okay, so for Frankie's situation, we're going to say you don't need to open a bank account. You can just get a check. That kind of answers the question because there won't be any enforcement anyway, but we're aware that he has this, they have this second issue. There's a judgment that might be expired. And let's say we do a court search and we find out that it hasn't been renewed. We know that the judgment is over 10 years old and it hasn't been renewed. And then Frankie tells you, oh, well, I haven't been able to get my driver's license because of this judgment. What can I do to get my driver's license now? So I will say that I've had some success in the past where there is an ICBC judgment, or with another credit if there's some other expired judgment, or writing to them and asserting that the limitation period has passed, asking them to clear it from their books, explaining that until now, that's prevented the person from getting their driver's license, that doesn't appear to be a basis for ICBC to deny the driver's license because of an outstanding debt. And can they, if they don't agree that the limitation period has passed, can they please write back explaining the basis for their opinion? Otherwise, please issue Frankie a driver's license. So a limitation period defense really can be quite a powerful thing. If we're finished with this fact pattern, we're going to move on to some more specific information about rights and remedies to do with using court mechanisms to enforce unsecured debts. And we had said we might have a break at 10:30. It's only 10:24, but I think it's a good time in the presentation to break. So shall we take a 15-minute break now, Lois, do you think?
Okay.
Okay, well, it's 10:41, so I think I'll just take it on faith that most people are back from their break and settle right into our new section, which is talking more about how unsecured debts can be enforced and what are the limits on enforcement and what remedies might apply for people who have had money taken or are worried about having money or assets taken. So our poor little piggy bank has taken a bit of a hit, but it can be glued back together in some situations. So I'm going to be looking at a couple of situations here. For example, we may have a situation where a creditor already has a judgment and their client is simply worried about enforcement and what the creditor might be able to do, or a creditor may have already enforced against somebody. So for example, they may have already applied to court for a garnishing order or payment order, and the client wants information about their rights and what they may have to do. So let's get right into it. If you can move to the next slide, please. So first of all, in order to forcibly collect money from a debtor, an unsecured creditor must first have a court judgment. If they don't have a judgment, then there is really no way an unsecured creditor can actually forcibly collect money or assets from a debtor, with one exception, which we'll talk about, which is to do with set-offs against bank accounts by banks, where there is a related credit card debt usually. So we know the creditor has to have a judgment. They can obtain a judgment in small claims court for up to $35,000 for amounts over $35,000. Jurisdiction lies with the BC Supreme Court. BC Supreme Court has its own enforcement mechanisms for creditors to obtain orders against debtors. We're not going to be talking about BC Supreme Court today because if you're dealing with a client with BC Supreme Court issue, they really need to be referred to a lawyer for advice. And in my experience, most of the clients that we see are dealing with enforcement mechanisms within the small claims court jurisdiction. So generally speaking, options for a creditor to enforce a judgment in small claims court include a payment hearing, where the creditor can ask for an order for a lump sum payment or installment payments. Other options include garnishing orders. We'll talk about in more detail, but most commonly garnishing orders are made against wages or bank accounts, and orders for seizure and sale of assets, which are used less commonly because they're quite expensive, but we'll talk about what they are and what limits apply to them. So as we're talking about these issues in small claims court, I really want to recommend the resource that I've linked there to the Justice Education Society's online help guide for small claims BC. I don't know how long it's existed, but I've only become aware of it in the last couple, maybe this year. I took a good look at it, and I think it's really excellent. It has very detailed, not only information about, let's say, what's a garnishing order in small claims court, for example, but say I'm a debtor and I want to dispute somehow a garnishing order or something else. What is the law that applies? It links to the law that applies. It links to the forms that need to be filled out. It has step-by-step advice about what you need to do in order to pursue the thing that you want to pursue. So if you're dealing with any issues in small claims court, I really think, or with enforcement in small claims, take a look at the guide. that I've linked there. So first, we're going to talk about payment hearings. So once a creditor has a judgment, in small claims court, they're actually officially called, the person is given what's called a payment order, saying, you debtor need to pay creditor, say, $5,000. I generally refer to that as a judgment, but technically it's called a payment order. So once there is a payment order, it's important to know that either the creditor or the debtor can apply for a payment hearing. A payment hearing is a hearing before a judge where a judge will review the debtor's financial situation and the judge is asked to make a payment order that the debtor can realistically afford. So this can be a very valuable thing for our clients because the client can provide detailed budget statements. Many of you, I think, probably have precedents that show, income, debts, assets, expenses, and in many cases, a budget sheet might show, for example, that at the end of the month, the person has $10 left over. And if a budget statement is properly and carefully prepared, then it would be very realistic for that person to go to the payment hearing and say, here's my budget information. I can afford $10 a month, because that's what my budget statement shows. And so I'm offering to pay $10 a month. And if the budget statement is well documented, a judge may very well make a payment order for an installment, a payment schedule for an installment of $10 every month. And the small claims rules say that if the debtor obeys that payment schedule, so let's in our example say the person continues to pay $10 a month, the creditor can't do anything else. They cannot use other methods to collect the debt. So establishing a payment schedule that's realistic for the person's circumstances can really fend off many other possible collection steps that the person might be worried about. And it can be a very useful way of creating some order in their financial situation, even though there is a judgment against them hovering in the background. I've also seen cases where, the person's budget statement says, I'm on income assistance and I'm a single mom, and here's my budget statement. And at the end of the month, I have $0 left, or I have negative $20 left. And I have seen judges in those cases say, okay, the payment schedule that I'm ordering is $0 a month. And if your financial situation changes, you must advise the creditor of the change in the situation. But in the meantime, the order is for $0, which again can be very helpful to ward off other steps the debtor or the creditor might take, and can really alleviate a lot of worry on the person's part. So what happens if the debtor has an installment payment plan set up at a payment hearing and then misses a payment? So if a payment is missed, either the creditor or the debtor can request a new payment hearing to change the payment schedule. So maybe our client that could pay $10 a month had an order for $10 a month, and they miss a payment. Let's say they missed the payment because there was a change in their financial situation. Their rent went up, and now they only have $5 a month that's available to them to pay. They can request a new payment hearing, go back before the judge, explain their situation, provide updated budget information, and they can ask the judge for a revised payment schedule for $5 a month, or whatever it is that they show them that they can now afford. So it's very useful for the debtor to do that, because if they don't apply for a new payment schedule, if they miss a payment and then don't apply for a new order, then the creditor can take other steps to collect the debt. So they could look at a garnishing order or seizing assets and so on.
Do you see the question about a creditor requesting a new payment hearing if the payment is late?
Can a creditor request a new payment hearing if the payment is late? Yes. So a late payment is essentially a missed payment. However, if you miss a payment but then you make the payment 5 days later. You mean, could the creditor apply for any payment hearing in the meantime, in those 5 days? I suppose so. But I would be surprised if they did. Most creditors, especially institutional creditors like credit card companies and so on, just want to be paid. And I would think that if, a creditor applies for a new payment hearing, even though they've already received the payment, it was just late, I think a judge wouldn't be too pleased about that situation because it's not really a change in circumstance. So, all right, so let's move on to talk about garnishing orders a little bit. So legally, there's two kinds of garnishing orders. There are garnishing orders that can be obtained before a creditor has a judgment. It's called a pre-judgment garnishing order. And then there's garnishing orders that can be obtained after a creditor has a judgment, called a post-judgment garnishing order. So for our clients and the types of debts they have, pre-judgment garnishing orders aren't something that come up very often at all. So for today's purposes, we're only going to be talking about garnishing orders after a judgment. So a garnishing order is a court order that a creditor can apply for. And it's a way for the creditor to get money that someone else owes to the debtor. So for example, let's say I owe money on my credit card. My credit card company gets a judgment against me. Maybe we have a payment hearing, and I should have said that another purpose of a payment hearing that can be very useful for a creditor is to find out more information about the person that they're enforcing against. So maybe we had a payment hearing and they discovered that I work at class in Vancouver. We had a payment schedule, but I missed the payment schedule for some reason. And so then the creditor decides to apply for a garnishing order against me. Well, they wouldn't apply it for, they would apply for a garnishing order against somebody that owes me money. So class in this example pays me wages. The creditor could apply to court for an order to have class, instead of paying my wages to me, have class pay the money into court under a garnishing order. So in this situation, we use the word garnishee to refer to the employer. That's the place or the entity or the corporation or the bank or whatever it is that is having money, being told to redirect money from the debtor, that's me in this case, to the court. So the garnishing order has the effect of having the garnished money paid into court, unless there's a reason for the garnishee to refuse to honor the garnishing order, which can include, for example, let's say a bank is served with a garnishing order to have welfare in a bank account paid into court. The garnishee, we'll talk about it more in detail later, the garnishee may have a good reason to refuse to pay money into court. So in my case, class garnished my wages and paid them into court. The next step would be for the creditor to apply to court for payment out of the money. The debtor would receive notice of this application, so I would be notified of the application. And there's different options that I might have in terms of any recourse I want to take. So there's strict rules and timelines that must be followed to get a garnishing order. And again, the Justice Education Society Guide to Small Claims BC has great information and detailed guides with respect to garnishing orders and also disputing garnishing orders. So I've linked that there again. Next slide. So if my wages are garnished, what does that mean? Do they take my whole paycheck and class just pays it into court and says, oh, never mind, Alison, I'll just get by this month, or what happens? So there's limits on the amount of wages that can be garnished. They're set by the Court Order Enforcement Act, and the limit is 30% of net income can be garnished. So that means I would still get 70% of my paycheck, 30% would be paid into court. The rule is different if the judgment being enforced is for child support or spousal support. In that case, up to 50% of wages can be garnished. A garnishing order only applies to wages payable within the next 7 days. That means for a creditor to try and collect, let's say there's a judgment for $5,000 and they can only get 30% of a paycheck at a time. To collect that whole amount by garnishing order, they're going to need to apply for one after the next, after the next, after the next. And each time a creditor applies for a garnishing order, they have to pay a court filing fee. And that filing fee is passed on to the debtor and added to the amount that the person owes. So that's one point to note with garnishing orders. Let's go back to my example and say that my wages have been garnished and it's caused me serious financial hardship. So where the person has serious financial hardship as a result of the garnishee, they can apply to the court to have the garnishing order released and a payment plan substituted. So that's an application under Section 5 of the Court Order Enforcement Act. And in order to succeed in having the garnishing order released and a payment plan substituted, the person has to show that this is a defined expression from the Act, just in all of the circumstances, to release a garnishing order and then substitute a payment plan. So basically the person needs to provide financial details of their situation, again, by a budget sheet, usually helpfully. An application for release of the garnishing order under Section 5 can be made without notice to the creditor. And if an installment payment plan order is made, either the debtor or creditor can apply to vary it in the future, just as we saw was the case with installment payment plans that are made after a payment hearing. And similarly to an installment plan after a payment hearing, if a Section 5 installment order is made for scheduled payments and the debtor complies with it, the creditor can't get another garnishing order. So complying with an installment plan prevents the creditor from further action here as well. So there's no particular test to show, how serious your financial hardship has to be in order to succeed in having the garnishing order lifted and an installment plan made instead. If the garnishing order is lifted, then the money that was paid into court would be paid back to the person as their wages, and then the installment payment plan would be payable going forward. Next, we've got a fact pattern kind of looking at some of the payment plan and garnishment issues. Lois, do we have any questions in the meantime in the chat?
No.
Okay, let's move on to the fact pattern then. All right, so here we have Mario. This morning, he says he has a Visa card and that the Visa card company has obtained a judgment against him 2 months ago for about $25,000. He's a single father. He earns $2,100 a month. He agrees that he owes the money, but he's really worried that if Visa garnishes his wages, he won't be able to afford his rent and he and his daughter will get evicted. And that's the only debt he has. So what can you tell Mario? Might you be able to help him? What can you tell him about his situation?
I guess if people want to pull up the PowerPoint, it would be in Shed if you want to go back to what Alison covered.
Yeah, someone's asking, is there a percentage that is based on how much can be taken in wages? Yes, up to 30% of net wages. Unless it's an order that unless the judgment being enforced is for family maintenance, and then the limit is 50% of wages. So someone's saying to prepare the payment for the payment hearing with a well-documented budget. So you would tell him he could apply for a payment hearing as the debtor, and that to prepare for the payment hearing, he should do a detailed budget. Yeah, so I think that's a good suggestion. You can apply to the court for serious financial hardship to the court release the order. So there's no order that's been made. We have the judgment that's been made, but there isn't actually a garnishing order right now. He's worried that Visa may garnish his wages. And if Visa, you could reassure him that, yes, look, okay, there's things we can do in the interim, in the meantime, but if RBC Visa does garnish your wages, there would be something you could do about it. You could apply to have it released based on serious financial hardship. Someone saying call lawyer to get legal advice, do detailed budget, income and expense statement. Right. So I think that's good advice, that he can, well, he could do a couple of things. So first of all, it's important to note that even if somebody, a creditor, has a judgment, doesn't mean that the person necessarily, the debtor necessarily has to use court procedures to try and come to some payment plan or some other solution. They can still try and negotiate directly with the creditor. I mean, the creditor, after all, really just wants to be paid. So it may be possible to negotiate directly with the creditor and through that to agree to a payment plan, a reasonable payment plan. But if the creditor, if the person doesn't want to do that, they might be intimidated by dealing with the creditor, or for whatever reason, they might rather use a court procedure. They can apply for a payment hearing in small claims court. If that's where the judgment was, which we're going to assume it was in small claims court because it was for under $35,000. As Becky said, he should do a detailed budget sheet to show what his disposable income really is or really isn't. And then he could ask the judge for an installment payment plan. Another option he has would be to do nothing. It's always an option to do nothing. Take a wait and see approach to see if RBC is going to do anything to collect against him. But because we know RBC has 10 years to enforce its judgment, he'd be waiting a long time, and 30% garnishment could, the garnishing order, garnishing 30% of his wages could happen at any time. Applications for garnishing orders are not served on the debtor. So the first thing the debtor knows about it usually is when their wages are garnished. And even though there's steps that they can take to follow up and have the garnishing order released, the fact that their wages are garnished often throws people into immediate financial crisis because bills are owing and rent becomes due, and it can easily become a very chaotic situation. Okay, so there's a few options for Mario there. Let's move on to talk about a slightly different situation. If we could have the next slide, please. Because garnishing orders can be made not only against wages, they can be made against any third party that owes money to the debtor. So as I said earlier, most commonly is wages and bank accounts, but sometimes advocates are on the other side of a file. So sometimes, let's say an advocate is helping a tenant try and collect on a judgment. The judgment from RTB says that the landlord owes the money. If the tenant was interested in applying for a garnishing order, you could look for different third parties that owe money to the landlord and issue a garnishing order against that third party. So for a landlord that has multiple tenants, garnishing orders could be obtained against other tenants that owe money to the landlord. So garnishing orders aren't limited to wages and bank accounts. it can be against any third party that owes the debtor money, but we'll talk specifically about bank accounts for a minute. So there are some limits on enforcement here. So joint bank accounts can't be garnished unless the creditor has a judgment against both account holders. The rationale there is that money in a joint bank account is considered to belong 100% to each owner of the bank account. So it would be unjust and unfair if money was taken out of a joint account where only one person owed on the judgment. So unlike the case with wages, the Court Order Enforcement Act doesn't limit the amount that can be garnished from a bank account. So that means up to the 100% of the judgment debt could be garnished from a bank account if there was enough money in the bank account to cover that amount. So if a client's bank account is garnished and a large amount of money is taken, that obviously can send them into, severe financial crisis. So avoiding garnishment is often, usually the best advice by having something put in place like a payment plan or other agreed installment plan ahead of time. But of course, that doesn't always happen. And if somebody has their bank account garnished, there are remedies that are available. So under Section 5 of the Court Order Enforcement Act, the person with a bank account that's been garnished can also, as is the case with garnishing orders against wages, for a bank account garnishment, the person can also apply to court to have the garnishing order released based on financial hardship and have a payment plan substituted. The test here is the same as it was for garnishing orders against wages. To release the garnishing order, the application must show that it's just in all of the circumstances to release the garnishing order and substitute a payment plan. So as we said on the previous slide, the person should prepare a detailed budget sheet showing their income and expenses. It can be a good idea to attach supporting documents to confirm the expenses that they're showing. So if you have a hydro bill of X dollars a month, you can attach a hydro bill to show that amount, and so on for all of the various expenses. And again, that resource of the People's Law School Small Claims Guide can be very helpful with this kind of application as well. Next slide, please. So now we're going to talk about some limits on collection.
Sorry, Alison, there's a question. Did you see the question from Andre in the chat?
No. What does she ask?
Says, what about the money already taken? Is there any way to reverse this if the debtor is now unable to pay rent and utilities?
Yes. So when the garnishing order is lifted, so if the person succeeds in their Section 5 application and the garnishing order is lifted, the money should be paid out of court to the person, back to the person. So the judge will have to make a decision. So let's say $1,500 was taken, and the judge hears a Section 5 application and decides, okay, you've given me a budget sheet. It shows you can realistically afford $30 a month. I'll make an installment plan order for $30 a month, and would probably say, I'm going to order all the money in court paid back to the person except for $30. So that would be the first payment on the installment plan. But the rest of the money would be paid back to the person. And then the judge would have the discretion whether to take the first payment out of that lump sum or not, I think. Okay. So as I said, there are specific limits on collection. An important one for advocates to be aware of is that there are various limits on collections set out in Section 89 of the Indian Act. So Section 89 says that creditors cannot seize or attach the real or personal property of someone with Indian status if the property is situated on a reserve, and that protection applies unless the creditor is a band or the creditor also has Indian status or is an agency like FMEP that is collecting on behalf of the parent, the other parent who is the creditor and also has Indian status. So for our purposes, we're primarily concerned with the status of personal property here. So creditors can't seize personal property of someone with Indian status if the property is situated on a reserve. It's not always easy or clear to determine what personal property situated on reserve means. Courts have struggled with trying to establish what that means. And so if you have a client with specific questions about what that exemption might mean for them, it is a good advice to refer them for legal advice. And there are also a couple of important exceptions to the Section 89 protections. So specifically, conditional sales agreements can be enforced on reserve. Conditional sales agreement is a specific kind of contract. It's often used for car purchases. And what is different about a conditional sales agreement is that instead of saying, okay, Alison, you're buying a car, you know, here's the car, here's your car loan, or I give them cash and I own the car and the car is legal in my name. If something's sold under a conditional sales agreement, I get the use of the car, but the contract says that the legal title to the car actually remains with the creditor. So if the creditor still has legal title to the asset, in this case, the car, then they can enforce against the car, even though it's located on reserve. The other exception is that leasehold interests in on-reserve land aren't exempted from enforcement. So again, there's a lot of lack of clarity, I think, in terms of what that situated on reserve issue means. And so just flagging this for you to be aware of. And in some cases, the client may need legal advice about their situation. And Anne is noting that you could refer to the Indigenous Community Legal Clinic for advice in those cases, and that's a great suggestion. So that's the Indigenous Community Legal Office that is affiliated with UBC. UBC law students work clinical terms there under the supervision of staff lawyers, and they do have a provincial mandate. So anybody in the province, anybody from anywhere in the province can refer cases there. So another important limitation on collection has to do with government benefits. And I will note that I've uploaded some materials on this in SCED. There's a handout to do with statutory protection of benefits and also some case law, I think 4 different cases, and a precedent letter. So we'll talk about what those things are, but they are available on SCED for you to take a look at and download. So most government benefits can't be garnished at source. That's an important protection. And what it means is that if, for example, somebody on old age security owes money on a credit card, the credit card company obtains a judgment, they think, oh, they're on old age security, I'm going to get a garnishing order. I'll apply to court for the garnishing order. The court may grant the garnishing order, and then they go and they serve the garnishing order on Service Canada, which administers old age security benefits. So if they do that, OAS will take a look at the garnishing order and say, oh, we can't pay any money into court under the garnishing order because OAS benefits have statutory protection from garnishment. So in that case, nothing would happen and the person would receive their OAS benefits as usual. So there are many statutes that provide protection for different kinds of government benefits. They're all worded somewhat differently, and it can be confusing looking at the specific language in a statute and saying, well, what does it mean exactly? So I've given one example here. The Employment and Assistance Act that applies to welfare says income assistance, hardship assistance, and supplements are exempt from garnishment, attachment, execution, or seizure under any act. So we don't really know what attachment, execution, or seizure means, I think. Those are different terms, each with a specific meaning. But we do clearly have a statement that it's exempt from garnishment, and we know now what that means. And you'll find that many of the statutes that provide statutory protection also have exceptions, and here's one. The exception is that this does not prevent welfare benefits being retained by way of a deduction or set off under the welfare legislation or the Financial Administration Act or a prescribed enactment. We don't need to worry about the details there. Basically, what it means is that there's an exception and that government may be able to withhold benefits if money is owed to government. So in the handout that's attached in SCED, you'll see I've got a list of all of the various kinds of statutory benefits I'm aware of that have some statutory protection from collection. I've also got links to the relevant sections of the legislation that apply. So there are many, and they do include some you might not expect, like Crime Victims Assistance Program payments. There's also some protection for Canada Child Tax benefits. One thing that's in the list I don't have on the slide is childcare subsidies under the Child Care Subsidy Act. You'll see there's also some protection for money in our RSPs and registered and RIFs, registered income funds. So all of that is detailed in the handouts that you can take a look at. Next slide, please. So there are two aspects to protection of government benefits that are less clear. We do know that a garnishing order can't be served on a government body. They won't respect it with respect to statutorily protected benefits. But wrinkles can happen because most benefits now are deposited by electronic funds transfer to bank accounts. And so two situations can happen. We know that a creditor with a judgment can apply for a garnishing order against a bank account, and that they can garnish up to 100% of the amount of a judgment from a bank account. So a creditor may do that, and the money in the bank account may be statutorily protected benefits. Is the creditor allowed to do that? And what can the person do if that happens to them? We'll talk about that a little bit. Another situation that can happen is that, again, benefits are in a bank account. Let's say the bank account is with TD, and at the same time, the person has a Visa or other credit card with TD that is overdrawn. They owe money on their credit card. What happens, not uncommonly, is the bank has, there's an agreement that the person signed when they first applied for their credit card. There's many, many pages of contract terms. And often in the terms, it may say that if the person is delinquent on their credit card bill, the bank can go in and scoop money out of their bank account and apply it to the credit card without needing a judgment, without first notifying the person. And so people can be taken very much by surprise when this happens, and can again be thrown into financial crisis because suddenly they don't have their EI benefits have been applied to their credit card and they don't have money for rent or food. So there are remedies that can apply in both of these situations. And the handout that I've included in SCED does detail those quite specifically. So where a garnishing order is issued against a bank account that consists of statutorily protected benefits, courts have found in a number of cases now that those benefits don't lose their character as being statutorily protected by reason of e-deposit only. And courts have ordered those garnishment orders to be reversed and had the money returned to people. So there's 4 cases now that I'm aware of. There's one called O'Brien that I've listed in SCED, and there's actually, I think it's an Ontario judgment. There's 2 cases now in BC that deal with that situation, which find that in one case, it was old age security benefits that had been garnished from a bank account, and the other, it was welfare benefits. And both of those cases, the court clearly said, no, these are protected benefits, they can't be garnished. In both of those BC cases, it's interesting that the bank actually was the one that stood up and refused to honor the garnishing order. And they said, oh, we're not going to honor this garnishing order because these are statutorily protected benefits. And they went to court to defend their position to the judge. The person involved didn't have to go to court at all. So it can be useful. Like, I don't actually know in those cases how the bank knew that they were statutorily protected benefits. I think when some government benefits are deposited, there's sometimes a code that will let the bank know, but not all banks are so much on the ball as that particular bank was. Both of those cases were in Kamloops, and it was the same bank involved in both cases, in Dixon and Bailey. So if you have a client that is getting statutorily protected benefits deposited to their account, it can be a good idea for the client to let the bank know that. And it can also be a good idea to have a separate account for statutorily protected benefits, because let's say somebody's on PWD and they're also working. They can earn now up to $15,000 per year without it being deducted from their PWD checks. So we know that their PWD benefits have statutory protection, but their wages don't, right? They are not statutorily protected. And so if those funds are in the same bank account and there's a garnishing order or a set off against that account, it can be difficult to try and show, which, if the money's really intermeddled, it can be more difficult to argue that the benefits should be protected because it's not clear which money is benefits and which money is wages. So similarly, we have a situation where a set-off can happen without a court order, where there's a credit card debt owed to the bank where the person also has a bank account. If a set-off happens and protected benefits are applied to the credit card, there's not much case law on this, but there have been many situations where advocates have been able to successfully have the payment reversed by generally writing a letter to the bank manager, asserting that the benefits in the account were statutorily protected, citing the legislation that they're protected under, explaining the financial impact that this has had on the person concerned, and asking for the money to be returned to the person's bank account. One of the items that I uploaded to SCED is a precedent letter that you can use to write to a bank in a situation of set-off. The example included in the template is somebody who had their PWD benefits set off, but you could adapt it to different situations. So if the money was CPP disability benefits that were taken, for example, you would just need to alter the template to include that legislation instead. And so I really encourage you to take a look at those and work your way through them after the presentation today. And then I'm just going to check the chat again, see if we have any questions.
No, you're good.
Good.
Yep.
All right, next slide, please. So we've got another fact pattern. This time involving Jaspreet. So Jaspreet is 75 and she receives OAS and GIS benefits of $1,550 a month. During the pandemic, she didn't want to have to cash checks, so she started having her benefits directly deposited in her bank account with ABC Bank. And she has a credit card there as well and owes about $10,000 on the credit card. So today she had a set-off happen. She went to the bank to withdraw her rent and discovered ABC had taken $1,200 of this month's benefits out and applied it to the credit card debt. And she says she won't be able to pay her rent or buy her food. So I think I gave the answer to this one away already, but let's have at it. What can you tell Jaspreet? Can you help her get that money back? And what would you do? I guess the first thing we need to find out, I guess what's true with any debt situation is that in order to find a path out of the debt situation, or to find out if there is a path out of the debt situation or the collection situation, we need to know, how did you get into that situation in the first place? So I guess the first thing we would need to know is it's possible that ABC Bank had a judgment against her. The fact pattern doesn't say if they did or they didn't. So we need to know if ABC had a judgment against her or not, in which case maybe it was a garnishing order, or maybe they don't have a judgment against her and what's happened is just a set off, like I described in the last, when we were talking about the last slide. So
Now you have a comment in the chat.
Right. So if it was a set off, we could write a letter to the bank to let them know they took the protected income. Sonia would definitely contact the bank about the situation. And I'm going to guess this was a set off, but the bank might say, oh yeah, we had a garnishing order. We did everything right. We have a judgment against her. She didn't reply. It's a default judgment. And we got a garnishing order against ourselves, which is a little bit absurd, but let's just say there's a garnishing order. Then you would have to act accordingly, right? You would need to apply to small claims court in the registry where the garnishing order was issued to have the garnishing order released under Section 5 of the Court Order Enforcement Act and to have an installment plan substituted. So I think that refrain of to know how to try and get out of a situation, you need to know exactly what led up to the situation is something that I would repeat a lot when it comes to debt and enforcement issues. Okay, so there's also limits that apply to judgment creditors when they're trying to seize assets. So I want to review those with you. So this is a remedy that is available, but that is, in my experience, used less commonly when it comes to clients that we deal with for a couple of reasons. So first of all, only court bailiffs can execute orders for seizure and sale of assets. And court bailiffs charge fees, and it is quite expensive to have orders for seizure and sale executed. So creditors, if it's a relatively small credit card debt, they're going to be reluctant just to, throw good money after bad to pay court bailiff fees. And then the other point is that many of our clients have assets that are exempt from seizure. So people are allowed to keep certain things even when they are having court orders enforced against them. And we're going to review what are those exemptions, what assets can you keep that are exempt from seizure. So first of all, jointly owned assets can't be seized unless the judgment is against all joint owners of the asset. So that's the same rule we already discussed when it came to joint bank accounts. So if it's a bank account that's owned jointly, or a car that's owned jointly. It can't be seized unless the judgment is against all joint owners. We've also reviewed the Indian Act exemptions, personal and real property for person with status, if situated on a reserve, is exempt unless a creditor also has Indian status or is a band, or it's a conditional sales agreement, or it's a leasehold interest in reserve land. So another exemption that applies is if there's a lien on the item. So if it's a secured asset, like an RV, for example, that has a car loan against it, then unsecured creditor can't just seize the RV and sell it. What happens instead is the lien holder is paid out first, and then the judgment creditor, the unsecured judgment creditor, would only be entitled to the amount remaining after the lien holder was paid out. So there's other important exemptions that apply, and they're all set out in the Court Order Enforcement Act and Exemption Regulation. And let's take a look at those now. So next slide, please. So here we have a list of the exemptions. So necessary clothing of the debtor and the debtor's dependents, with no financial limit on that, on the value of the necessary clothing. Medical and dental aids required by the debtor and the debtor's dependents, again, with no dollar limit on the worth of the medical and dental aids. $4,000 for household furnishings and appliances. When we say $4,000, what that really means is that if you were to value those goods, it's not replacement value. It's not how much would it cost to replace everything in your household. It's if you were to sell everything in your house at a garage sale or on Facebook Marketplace or in an auction of some sort, how much money would you be likely to get for it? And so for most of our clients, I think that most folks that I've dealt with find that their household furnishings and appliances would resell for less than $4,000 and be within that exemption. There's also an exemption for equity in one motor vehicle. The exemption is $5,000 of equity. Again, if the judgment being collected is for child or spousal support, the exemption is less. In that case, it's $2,000 worth of equity. There's also an exemption for $10,000 of equity for tools and other personal property of the debtor that are used by the debtor to earn income from their occupation. And next, an exemption for equity in a principal residence. So if somebody owns their home, the exemption is $12,000 if the house is located in Capital Regional District, which is basically Greater Victoria, or Metro Vancouver Regional District. And elsewhere in BC, it's $9,000 of equity in a home. So that section has not been updated in many, many, many years. And of course, those numbers are now quite out of date in relation to house values in BC. And I'll talk in a minute more about what happens if they own a home that has more equity in it than that. And there's also some exemptions for RRSPs, money in RRSPs, and registered retirement investment funds, I think is what RIF stands for. There's a rule that says if you put money into the RRSP or the RIF in the 12 months prior to judgment execution, then that won't be exempt. So there's some very specific rules about RRSPs and RIFs, but if a client has an RRSP or a RIF, they should be getting specific advice. So there's a procedure set out in the Act for how a client is to claim the exemptions. So we know that only a court bailiff can execute against assets, and the bailiff needs to advise the person that they have the right to exemptions. And once the person has been advised of their right to claim their exempt property, they have 2 days to do that. They claim their exemptions, and the Act sets out a procedure for if there's a dispute about the value of the property. Maybe the bailiff thinks that something they're wanting to claim as exempt is worth more than what it's allowed to be worth. The Act sets out a process for how to settle that dispute, but again, it's usually not relevant for most of the clients we're dealing with because the value is usually clearly below the exemption. And it's interesting to note, so these asset exemption levels may be familiar to many of you, because they apply to any civil court order being enforced against a client in BC. Like, it's the same exemption that applies. So in the tenancy context, if a landlord has an eviction order against a tenant and has filed that in BC Supreme Court to enforce it, and a bailiff then is enforcing the eviction through a writ of possession, these same exemptions apply. They apply in the case of any court order being enforced. So when the bailiff enforces the writ of possession, the tenant is allowed to claim these same exemptions as they are in the small claims court enforcement context we've been talking about. They also apply to clients who declare bankruptcy under the bankruptcy legislation. So they're really important exemptions to bear in mind. So I talk a little bit more about the situation where equity in a house or equity, say, in a car is more than the exempt value. Basically what happens there is that, so say it's a car with $10,000 worth of equity, the car could be seized and it would be sold. Bailiffs sell things at auction. Let's say it sells for $10,000. The $5,000 of exempt equity would be then returned to the debtor, and the remainder balance would then be collected by the bailiff to be paid over to the creditor.
Alison, there's a question from Christy if there's any considerations if a person resides in the motorhome as their primary residence.
So I think a motorhome would be considered a principal residence. And so there would be $9,000 worth of exemption. I will say, though, that the rules for forcing a sale of a house are very complicated. Generally, there has to be a separate application brought to Supreme Court in order for specific action to be taken against somebody's home, specifically because of the recognition that that's their home, and there's no public policy interest in generally pulling people's residences out from under them, and certainly not for a credit card bill. So it's complicated. It's not likely that that would actually happen, I think, in any of the files that we're seeing in our offices, but theoretically it can. So May has called us on intake this morning. She says that a Visa card company recently obtained against a judgment for her for $45,000. She usually works as a self-employed house cleaner, but she had a family crisis last year and was out of work for a while, during which she had to live off, oh, sorry, that should be her credit card. May is back at work now, so she's back to her self-employment, but is really worried that the creditor might try to seize some of her belongings. She needs her van and expensive vacuums and appliances and other cleaning supplies for work, and she thinks they're worth about $30,000 in all. She asks you for your help with this. Oh, what can you tell? Sorry, another typo. What can you tell me? So there was an exemption for $10,000 for tools and other things needed to earn her income. And
you have an answer there now.
Oh, $5,000 exemption for the vehicle and $10,000 for the tools, right? And it looks like she's over that. So what can she do to try and avoid seizure if that's what she's worried about? She's working, so she also has wages. Also, what can we make of the fact that the judgment is for $45,000? Is that a red flag for anybody? What's the financial limit for small claims court?
Sorry, Sonia and I are on a direct message thing. She means to put it to the group. So she said they could apply. She could apply for a payment hearing, and you'll see other comments there too.
Yeah. So folks are now saying, oh, it's a Supreme Court matter. Yep. So the red flag is that small claims judgments can only be for up to $35,000. So this one's $45,000. So really good chance it's going to be a Supreme Court judgment. So that means that, judgments are enforced in the level of court where they were made. So the enforcement mechanisms, hearings here would be in Supreme Court, which we haven't talked about today because it's unusual to have a Supreme Court issue for our clientele. But basically, the hearings in Supreme Court have slightly different names and the procedures are different, but there are things that are equivalent to payment hearings and garnishing orders in both levels of court. So, but because it's Supreme Court, she should be referred for some legal advice. Can she apply to enter into a payment plan? Yes. So, like we were saying earlier on another slide, just because there's a judgment doesn't mean that the person has to use court procedures vis-a-vis the creditor. So one thing that you could help with is contacting the judgment holder and saying, that she's interested in coming up with a payment plan and she'd like to discuss that with them and see if it's possible to negotiate some reasonable agreement there. If it is, great. If it isn't, and they say we want $500 a month and she says I can only afford to pay $100, then refer her off to a lawyer because it's a Supreme Court matter, and she could apply to Supreme Court for equivalent of a payment hearing to try and have an installment plan ordered by a judge there.
There was a question way back about whether she could apply for hardship since she was out of work for some time.
Oh, so that's referring, I guess, to hardship benefits from the ministry. She's back at work now, so can't apply retroactively for things from the ministry. So maybe when she actually had the crisis and was off work last year, maybe she could have. I think we don't know enough about her financial situation then to know. But hindsight is 2020, and I think now we can't send her back to apply after the fact. Okay, I'm not seeing anything else coming in through the chat. So I will say at this point, we've just got a bunch of fact patterns left to work through. So I know some of you really like fact patterns, so let's move on to the next one and see what we've got. All right, so here we have Jamie. So Jamie's been our client for a while. They call us today and let us know a debt collector has been calling them about an old credit card they used to have when they lived in Vancouver 6 years ago. Jamie hasn't used the card since then or paid anything and thought the credit card company had forgotten all about it too. They told the debt collector they're on welfare and can't afford to pay anything. Jamie says they just have an old car worth $2,000 and the stuff in their apartment. What can we do to help them? Should you tell Jamie to pay the credit card company? Should you tell them to make a payment?
No. No.
Is Jamie acknowledging the debt by telling them she can't afford to make a payment plan? No. So an acknowledgement, great question. An acknowledgement happens in two ways under the Limitation Act. So partial payment or written acknowledgements that has to be signed by the person that they owe the debt. So no, simply saying that they can't afford to pay it isn't an acknowledgement. It doesn't restart the limitation period under the Limitation Act. Is the debt collector located in BC? If so, the 2-year rule might apply. Yeah, the debt, it's not the location of the collector that matters, it's the location of the debt. So this debt arose in Vancouver. So I would say the BC Limitation Act applies. But great point about where the debt collector is located, because sometimes, people do get calls from debt collectors that are located in other provinces. Maybe you get a call from a debt collector in Alberta, and the BPCPA applies no matter where the debt collector is located. If your client's in BC and the debt collector is trying to collect a debt in BC, the debt collector needs to be licensed in BC, even if they're physically located in another province. So one thing you could check out in that situation is, is this debt collection company actually licensed in BC, or are they operating illegally? You can, on Consumer BC's website, you can look up the names, you can look up the name of the debt collection company and check out the status of their license in BC. If they're not licensed in BC, you might want to call up Consumer Protection, confirm that information, and you can file a complaint against them because they're operating illegally, essentially, in BC. Send a letter to the debt collector to get lost. Yeah. That would be the section 116.4C of the Business Practices and Consumer Protection Act. You could dispute liability for the debt. What would be a reason to dispute liability for the debt here? Send a letter to the debt collector saying Jamie does not acknowledge the debt and limitation has expired. Ask for future communication to be in writing. Yeah. So a good reason for Jamie to dispute their liability for the debt would be that it does appear that the limitation period has expired here. So we know there's a 2-year limitation for unsecured credit card debt. The credit card is 6 years old. They haven't used the card since then or paid anything. Now, clients' memories aren't perfect, so they may be right about that, they may be wrong about that, but it seems like there's a good argument that the limitation period has expired. And so you could write to the debt collector and the creditor saying that they dispute their liability for the debt because the limitation period has expired, and asking the creditor to take it to court. What else could you include in that letter? She's currently on income assistance. Yep. So even though Jamie doesn't acknowledge that they owe this debt, in fact, they specifically dispute their liability for it because we think the limitation period has passed. Period, new paragraph. And by the way, I can let you know that my client is on income assistance. They subsist on X dollars per month. So informing them about their financial situation, so that in that case, you're doing 3 things with the letter. You're getting the collection calls to stop. You're saying, I think we're disputing the debt. There's a defense here under the Limitation Act. And then thirdly, even if the creditor thinks, maybe unbeknownst to you, Jamie made a partial payment 18 months ago and they just forgot, right? Maybe unbeknownst to you, the limitation period has not expired. You still want to give the creditor information about the person's financial situation because you can't get blood from a stone. And so if it's not going to be worth the creditor's while to sue this person because their income and assets are exempt from collection, they're below the levels they're allowed to have for assets, and they're on statutorily protected benefits, it's a good idea to tell the creditor that in your letter disputing liability for the debt so that they have that information. So when the ball's back in their court trying to decide whether to sue this person or not, they'll say, oh, period issue. Okay, we could look into that. But no matter even, regardless, this person is judgment proof. And so that would, be very persuasive to them in deciding not to pursue any further legal action on it. Excuse me. Okay. We have one more fact pattern and only 3 minutes left, but let's take a look at it. Next slide, please. So now we have Lauren. So Lauren is a truck driver in a long haul trucking company. Lauren has several creditors and feels like the world is closing in on them. Yesterday, one of the credit card companies he owes started a small claims action against him. He has a reasonably steady income, though he does have some layoff times. He has a wife who has a small home daycare business, and they have 2 school-aged children. So together they earn about $3,500 a month net, but after rent of $1,800 and other expenses, they find they have $200 or $300 to pay off all their debts in a month. 2010, he was involved in a car accident and ICBC said it was his fault and his premiums went up. He hasn't heard from ICBC since then, but he fears he may owe them some money. He also has several credit card debts totaling $20,000, a bank loan for $12,000, and a loan from a payday lender for $15,000. So this is a very complicated fact pattern, I will say, to close the session off with, because there are several different issues intertwined there. But I know we have some very experienced advocates in the Zoom room, so I'm curious to see how you unravel this. The question, is Lauren disabled? I don't think so, because he's working pretty steadily, so it doesn't sound like it. Referral to Credit Counseling Society. Yep, I think that's a good idea. He has a few debts. Are there any debts in particular that you think you might be able to do anything for him about, or would you refer the whole thing over to Credit Counseling Society? Refer to credit counseling to make consumer proposal, or have Credit Counseling Society figure out if there's a viable way to manage his debt load. What about ICBC? Is there anything special about the ICBC debt?
You have some comments in chat.
What's the limitation period that applies to ICBC? So ICBC is a branch of government. Well, it's a governmental agency. So what's the limitation period that applies? Someone's saying too old, limitation, 6 years. So we saw when we were looking at exceptions to the basic 2-year limitation period that under the Financial Administration Act, there's a 6-year limitation period for debts owed to government. So that applies to, say, welfare overpayments. It applies to MSP premiums, ICBC money. Someone said 10 years. It's possible. Well, I guess one of the facts we don't know is, does ICBC have a judgment against him? So if ICBC actually went to court and got a judgment against him for the car accident, then that judgment would be good for 10 years. So I guess it's a little bit gray, like many intakes often are, right? There's more information we would need to get. But let's say we look into it and we find out ICBC never got a judgment. So he fears he may owe them some money. He doesn't know. So I would just flag that there might be a limitation issue If there is a debt to ICBC there, you would need to find out, okay, what is it? Is there one? He fears there might be one, but is there one? How much is it? And is it a judgment debt, or is it just the bill that they sent him? Bankruptcy?
There's a comment from Andre that if he still has his license, maybe on ICBC hasn't done anything.
It's true, because we know he still has his license because he's still driving truck, right? So it's because usually if you have outstanding debts to ICBC will put a hold on your driver's license, which is often, a flag. The inability to get a driver's license can be due to outstanding motor vehicle indebtedness. So again, a gray area. Bankruptcy, yeah, maybe bankruptcy might be a remedy for him, but in order to be eligible to declare bankruptcy, he has to be unable to propose a viable proposal to his creditors. So I think you would still refer him to Credit Counseling Society because they're the experts in trying to negotiate solutions for using debt management tools. Maybe they can in this case, maybe they won't be able to. If he's actually overwhelmed by his debt, then bankruptcy might be something they recommend him to find more information out about. Consolidation with a payment plan. Yep, that's one of the things. So one of the things Credit Counseling Society can work on is a debt consolidation with a payment plan. So I think we've caught most of the things that I kind of intended in the fact pattern. Flagging the questions about the ICBC debt, referring him over to the Credit Counseling Society, but maybe you do some sleuthing, extra sleuthing on the ICBC debt for him first. Oh, we missed one piece. So credit card company started a small claims action against him yesterday. So that means yesterday he was served with a notice of claim in small claims court. So what are we going to do about that? He's going to need to file a response. Well, he should get some advice about whether he should file a response to that or not, just to not miss that one piece of the puzzle. So we don't know if he agrees that he owes that money to the credit card company or not, or if he might have a defense. So he should be referred to get some advice about that. Application for a payment hearing. So let's assume he does owe the money. He may agree and a judgment may be made. Then he could apply for a payment hearing so that credit card company, that credit card judgment debt is taken care of in a structured way with a payment plan. Okay, so I see we're at 12:06, Lois, and the chat is slowing down. I can stay, I know there's another session at 1 that I'm going to go to, but I can stay for a bit.
It's self-care.
It is.
So maybe we should
have a general questions slide, which is really for questions, hopefully related. I know people have lots of debt questions, and with debt, we have to just chip away bit by bit at the areas that we learn about. So questions that might arise in relation to some of the things we discussed today, feel free to pose them. And I think Lois and I will take away that there's a good appetite for a workshop specifically on student loans. And to that, I would add, there's specific rules around bankruptcy and student loans, and we could have a workshop dealing with both, I think. If there's other debt issues that you would really like to know more about, I think it would be helpful to us if you could put those in the chat as well.
Please do. But given that we're encouraging all of you to consider self-care this afternoon, I'd say maybe if people want to follow up with Alison, that you do that separately after the session. Does that make sense?